Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2, Jefferson County, Texas. My name is Judge Terrence Holmes. I'm the presiding judge here. Today, we have our arraignment docket. And what the arraignment docket is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, the case that you have in this court is a misdemeanor case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are commonly referred to as your more serious type of criminal offenses, and your misdemeanor cases are referred to as petty offense. It does not mean that they are not serious. It just means that they are not as serious as your felony offenses. If you had a felony case, your felony case would either be a capital murder, first-degree felony, second-degree felony, third-degree felony, or a state jail felony. And the range of punishment for a capital murder, if you're convicted, is life or death. For a first-degree felony, is 5 to 99 years to life, fine up to $10,000. For a second-degree felony, the range of punishment is 2 to 20 years. In the state penitentiary, fine up to $10,000. For a third-degree felony, the range of punishment is 2 to 10 years in the state penitentiary, and a fine up to $10,000. Now, if you had a state jail felony, which is the lowest felony, the range of punishment is 2 years. The range of punishment starts at 6 months to a maximum of 2 years in the state jail, a fine up to $10,000. Now, I mentioned to you earlier that the case that you have here, or the cases that you have here, is classified as a misdemeanor case. Because it is a misdemeanor case, your punishment cannot entail that you be sent to the state penitentiary. However, your punishment can entail, if you have a Class A or Class B misdemeanor, that you can be sent to the county jail. Now, your misdemeanor cases are divided into 3 categories: Class A, Class B, or Class C. If you have a Class C misdemeanor, which is normally a case that has been appealed up from the JP court or from the municipal court, the city court, you cannot be given time in the county jail. You only can be sentenced to a fine only. Now, if you have a Class B misdemeanor, the range of punishment for a Class B misdemeanor is confinement in the county jail, either start at 0 days all the way on up to 180 days, a fine from $0 to $2,000, or you can be given both such fine and confinement. The range of punishment for a Class A misdemeanor is a minimum of 0 days in the county jail to a maximum of 365 days, or you can be given a jail time anywhere in between, or you can be given a fine from $0 to $4,000, or you could be given both such fine and confinement. As a defendant in a criminal case, you have rights. Now, first right that I will go over with you is that you have a right to have an attorney. And paperwork that has been passed out to you states that as a defendant in a criminal case, you have 3 options regarding your right to have an attorney. 1, you may hire an attorney. Or number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number 3, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, You may change your mind at any time and may request counsel from the court. At the bottom of the document that has been handed out, it states defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you will put your initials on the first line to the left. If you have already hired an attorney, then you will put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you put your initials on the third line to the left. If you have already been appointed a court-appointed attorney, then you will put your initials on the fourth line to the left. Now, if your choice is, I want to waive my right to an attorney and represent myself, then you'll put your initials on the fifth line to the left. Now, once you finish initialing one of the 5 lines, you will sign at the bottom of the document on the line that says defendant, and you will date it today's date, January 18th of 2022. Now, for those of you who will be representing yourself, you will go to the next page as well. The next page is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And it reads, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 18th day of January of 2022 by the County Court at Law Number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that's your choice, you will sign on the line where it says defendant, and you will date it today's date, January 18th of 2022. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. Where that gentleman is sitting in that area, we call that the jury box. You have a right to have 6 citizens from Jefferson County to sit on your jury, and they will decide whether or not to find you guilty or innocent after listening to all of the evidence in your case. You also have a right to waive your right to have a trial by jury, which means you have a right to give up your right to have a trial by jury. And by doing so, you will not be having a trial by jury. Now, if you do that, then your case will come before the judge or before the court in one of 2 ways. It could come before the court by way of a trial or a plea. If it comes before the court by way of a trial, we call that a bench trial. That is, it would be before the bench, before the judge. The judge would be the judge and the jury in your case. That is, the judge will decide whether or not you're guilty or innocent. And if you're found guilty, the judge will also assess your punishment. Now, your case can also come before the judge by way of a plea. And it could come before the judge by way of the plea in one of 2 ways. First way is if you have an agreed plea bargain agreement. That is, if you and the state have reached an agreement to settle your case, we call that a plea bargain agreement. Now, if your case comes before the judge on a plea bargain agreement, the judge does not have to follow that plea bargain agreement. If the judge does not follow that plea bargain agreement, you'll be entitled to withdraw your plea or take back your plea. Your case can come before the judge by way of an unagreed plea. What an unagreed plea is, it means that you and the state have not been able to reach an agreement in your case. However, you still would like the judge to determine what your punishment will be in your case. We call that an unagreed plea. Now, you also have a right to have witnesses to come to court. This area over here with that empty chairs, we call that the witness stand. And what a witness does, a witness can either testify for you or against you. You can ask them questions. We call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court. That simply means that you have a right not to call any witnesses on your behalf in your case. And by doing so, you will not be calling witnesses. However, the state will be calling witnesses on their behalf in your case. Now, you also have a right against self-incrimination. What that means is you have a right not to testify in your case, and the state cannot force you to testify in your case. Now, you also have a right to waive or give up your Fifth Amendment right against self-incrimination. And by doing so, if you're waiving your right or giving up your right not to testify, that simply means that you will be testifying in your case. You also have a right to have discovery, and discovery means that you have a right to see the evidence that the state has against you. You have a right to see the witness statements, police statements, the documents, the videotapes, DVDs, whatever the state has, the objects. You have a right to have access to that evidence. Now, you also have a right to waive or give up your right to discover. That means that you're saying that you would not, you do not want to have access, or you do not want to have discovery of the evidence in your case. Now, everyone here has, you have been arrested in your case, and you're currently out on bond, either a PR bond, a surety bond, or cash bond. Now, every day that you spent in jail on your case, that can be used as credit toward your punishment. So, for example, if you spent 5 days, if you and the state has reached an agreement, say the agreement is 5 days in jail, and you've already spent 5 days in jail, that 5 days can be credited towards your punishment. That just simply means that you will not have to spend any more time in jail because you've already spent 5 days in jail. Therefore, you'll be given credit for time served. You also can be, the time that you spent in jail can be used toward your fine and court costs. What that means is this: if you spent time in jail and you reached a plea bargaining agreement with the state, and that agreement is for you to pay a fine and court costs. Let's say you spent 5 days in jail. That's equivalent to, you get $100 a day credit toward the time that you spent in jail, so that's $500. And the state is offering that you pay a fine and court costs of $500. That simply means that you will not have to pay anything toward the fine and court costs. Why? Because you spent 5 days in jail. 5 days in jail is $500, and so therefore your fine and court costs will be taxed and retired. Now, let's say you're unable to pay the fine and court costs at all. You're not working, you have no source of income, and you can't pay it. Then what the court can do, the court can convert your fine and court costs to community service. That just simply means that you'll be able to work off your fine and court costs. And every hour that you work in community service, you will be given $12.50 that will go toward your fine and court costs. So if you work an 8-hour day, that's $100 that will go toward your fine and court costs. Jefferson County has a program that is called pretrial diversion. With that program, pretrial diversion is for first-time offenders. And if you get into the program, they dismiss the case, and then you can get it expunged from your record. Expunged means wiped off, erased, or deleted from your criminal record. Now, in order to qualify for that program, it has to be your first offense. It cannot be an offense involving unlawfully carrying a weapon or resisting arrest, and you have to have an attorney to assist you to get into that program. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County has a program that is called Veterans Court, and it's for veterans only. And that program is part of the pretrial diversion program as well. That just simply means that once you get into the program, You complete the program, the case is dismissed, you can get it expunged from your record. This court, this court has a program that is called the Community Safety Initiative. That's a program that I started March of 2017, within 100 days after taking office. And that program is designed to address the issue of what we call recidivism. Recidivism means where people commit crimes over and over. And so the way we address recidivism is we have partnerships with agencies in our community. And those partnerships that we have in the community, we have a partnership with Spindletop, our local, it's the Spindletop Center, our local mental health agency. And we have officers in court who are able, we have a mental health officer as well as a counselor in court who Spindletop is able to do a private interview. Spindletop can do an assessment plan, and they can do an assessment, and they can develop a treatment plan to address your mental health needs. Now, when I say mental health needs, I'm not talking about just a person who's incompetent or insane, but we are talking about individuals who have any one of the mental health issues, such as a person can suffer from depression, anxiety, post-traumatic stress. It could be paranoid schizophrenia, bipolar, just a whole host of any one of these or more of mental health issues. Spindletop will be able to address it. Now, the other thing is if you have an issue with drugs and alcohol, and if you have an issue with drugs or alcohol, Spindletop has a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. And with that program, Spindletop or OZOR can do a screening, an interview. They can develop a treatment plan, either outpatient or inpatient treatment to address your drug or alcohol issues. Now, if you're unemployed, do not have a job, or if you have a job, you want to get a better job, we have a partnership with the Golden Triangle Empowerment Center. The Golden Triangle Empowerment Center has a program that is called CICE. The Golden Triangle Empowerment Center has that partnership with Lamar University. Lamar University has the program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program in the hotel industry, the shipping industry, and the chemical industry. And once you are trained in one of the areas that you select, they will assist you in getting a job in the area that you're trained in. If you have not graduated from high school, then CICE also has a program where you can get your GED program. You get your GED certificate. And those programs that I've just mentioned to you, all of those programs are free. It does not cost you anything. Only thing you have to do is have a desire to be in those programs. Now, those programs are designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and go to church. Also, and I tell people this all the time, when you come to county court at law number 2, we don't have court as usual. We have unusual court. It's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this bench. And we're trying to make a difference in Jefferson County, the county in which we live. In county court at law number 2, we do not just give out time, we take out time. And I'm saying that to say this, we do not just arrest the problem, we address the problem. And so with these programs are designed to make Jefferson County not only a safer place, but it's designed to make productive people. And we believe that producing productive people would not commit crimes. And so that's how we address the issue of recidivism. And as I said earlier, all of these programs are free. We have their brochures that we can give to you if you're interested. Now, we also have with us Deputy Hinton. He's a mental health deputy in Jefferson County. And Deputy Hinton is going to come forward and tell you something about the programs that they have for you at Spindletop. Deputy Hinton.
Thank you, Your Honor.
You are.
Good morning. My name is Steve Hinton. I am a mental health deputy licensed by the state of Texas. I'm here also with partners of mine in the back room, qualified mental health professionals. We're here for one reason. That's because the judge has graciously allowed us in his courtroom because he cares about every single person that comes before his court. And what the judge has found, more so than not, that people who have legal issues in serious court commonly have mental health or substance use disorders that are causing some of the legal issues that you have. The judge believes that if we can address these underlying issues, we can get you out of the cycle of arrest. Now, should this be your first time here in this courtroom or your 10th time here in this courtroom, there are options, there are services, there's opportunity for you to help yourself. It's going to take one thing. It's going to take y'all reaching out. Should this apply to y'all? You're going to have to request help, and we're going to be here for you. This is what we do. We advocate for you in the courtroom. At the very least, I want to give you this flyer. This flyer tells you a little bit about our court program. It also has a number on here, 1-800 number. It is a crisis hotline. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. There's also another number there. You can call Spindletop anytime, and you can get information on how the best way to address your situation. Now, we can speak to you today privately and talk to you and advocate for you and kind of point you in the right direction that best fits your situation. If you want to do that, you're voluntary, so it's up to you if you want to participate in this, but at the very least, we want to get this to you. Now, if this doesn't apply to you, maybe it applies to a family member, we'd still like to get this information to you so that you could bring this to your family member or a friend that you may know who's suffering from mental health or substance use disorders, so they can get the help that they need as well. Does anybody have any questions? Thank you all very kind for listening. Thank you, Your Honor.
All right. Thank you, Deputy Hinton. Okay, ladies and gentlemen, at this time, what we're going to do is the paperwork that we passed out to you earlier. We're going to we got to pick that up, and then we're going to put you in various categories, and then we'll have you to come up before the bench. So that's going to take just a little time for us to do that, sort through the paperwork. And so at this time, we'll be in recess. And if you need to, if you got your, they're gonna, the court staff is gonna pick that paperwork up from you. So just hold on a minute and we'll